Hi, this is Eddie Best with Mayor Brown. Thanks for joining us today to discuss the SEC's recent proposed amendments to the rules governing Schedules 13D and 13G. During the next 60 minutes, we will cover proposed changes that would shorten multiple filing deadlines for Schedules 13D and 13G, proposed amendments relating to how cash-settled derivatives and swaps are treated vis-a-vis Section 13D reporting, proposed amendments to clarify when persons are deemed to act as a group under Section 13, the effect of the proposed Section 13D amendments to the beneficial ownership definition on Section 16 filing requirements, and finally, the effect on activist interest and strategies and ongoing private transactions. Next slide, please. Section 13D was originally enacted in 1968 as part of the Williams Act. The Williams Act came in response to the then increasing use of cash tender offers in hostile corporate takeovers. While even I wasn't practicing law that far back, I suspect that the level of hostile takeovers was nothing compared to what we saw in the 1980s and thereafter. But be that as it may, the Williams Act introduced a number of different regimes to both insider trading reporting as well as tender offer rules. Section 13D generally requires investors who acquire beneficial ownership of more than 5% of a class of equity securities registered under the Exchange Act to publicly report their holdings by filing a Schedule 13D with the SEC. Today, you'll hear us say generally an awful lot because there are numerous exceptions and exemptions in the rules under Sections 13D and 13G. For example, institutional investors and passive investors generally file on a shorter form Schedule 13G. Section 13G of the Exchange Act requires any person who beneficially owns more than 5% of a class of registered equity securities to report their ownership. This is generally done on a short form Schedule 13G. Thus, for example, Section 13G picks up stockholders who beneficially owned more than 5% of a company's securities prior to the issuer's IPO. In other words, they never acquired 5% of a registered equity securities. They acquired their 5% before it became a registered equity security. Last month, the SEC proposed amendments to modernize Schedules 13D and 13G and the rules relating to beneficial ownership reports by making information available to the public in a more timely manner, deeming holders of certain cash-settled derivative securities to be beneficial owners of the relevant underlying security, and clarifying the disclosure requirements in respect of derivative securities. Next page, please. Next slide, please. Thank you. Oops. Go back up one to the basic requirements. Thank you. As noted before, Sections 13D and 13G require investors who acquire beneficial ownership or who beneficially own more than 5% of a covered class of equity securities to publicly report their beneficial ownership. Schedule 13D is the default reporting form and generally must be filed within 10 days after the acquisition of the 5% or going over 5%. Schedule 13G is used for institutional investors, passive investors, and for certain pre-IPO holders. Institutional investors, such as mutual funds, and pre-IPO stockholders generally file a Schedule 13G within 45 days after the end of the calendar year, and passive investors, in other words, any other investor who acquires 5%, generally must file 13G within 10 days of going over the 5%. The current deadlines have not been amended since the 1970s. Next slide, please. The proposing release acknowledges that the shortening of the initial Schedule 13D filing deadline may have a chilling effect on an investor's ability to acquire control and incentive to effect changes of companies, even those changes that may be beneficial to all shareholders. The SEC, however, posited that the shortening the deadline would not be unduly harmful since most Schedule 13D filers did not wait the full 10 days anyway. The SEC cited a report that 23% of 13Ds were filed on day 10, meaning 77% were filed before that, though it's unclear how many of those were filed on days 8 and 9. The proposing release cites academic studies regarding the economic analysis and notes that there are several reasons to expect that this effect, including its impact on corporate control, would be limited. However, the SEC didn't provide an awful lot of detail about exactly how limited it would be. Further, there's little other economic analysis with respect to the changes related to derivatives. Next slide, please. So just a quick background to the proposed release. There have been a few proposals to amend the filing deadlines and some other aspects of Section 13D reporting in the past. The 2020 Dodd-Frank Act provided the SEC with authority to adopt rules to shorten the 10-day filing period and to require beneficial ownership reporting of security-based swaps. But until now, the SEC hasn't actually used that authority. In 2016, Senators Tammy Baldwin of Wisconsin and Jeff Merkley of Oregon introduced a bill that would have amended 13D and 13G to shorten the 13D reporting period to 4 days and would have modified the definition of beneficial ownership by making it broader and including pecuniary and indirect pecuniary interests and setting a methodology for calculating beneficial ownership in the context of derivative instruments. So taken together, the 2016 bill and the 2020 Dodd-Frank now have obviously resulted in the SEC's new proposal. The 2016 Act also never went anywhere, but now we have the new proposals. So with that background, I'm going to turn the presentation over to Marla, who's going to walk us through the proposed new filing deadlines, amendments, and formats, and you'll hear from me a little bit more later. Thank you.
Thanks, Eddie. So as Eddie mentioned, there are several categories of investors, each of which is subject to different requirements, from the activist investors subject to the most stringent requirements, through to passive investors that are 13G filers, but still subject to more requirements than the institutional or exempt investors. And there have been proposed changes to the requirements for each of these classes. On the current slide, we've kind of done a quick overview of the current requirements. And if we can move to the next slide. On this slide and the next 3 slides, we've summarized a bit of these changes, which we've outlined all of these changes, which I'll summarize for you now. So for active investors who were previously filing within 10 days, that deadline has now been moved to 5 days. And that's 5 days from either when they've crossed the threshold of 5% ownership or when they've lost their 13G eligibility, for example, by becoming part of a group with an activist investor. And the deadline for making an amendment to a prior filing has also been updated for any material change. Previously, there was a bit of a vague stance of the filing must be made promptly after the material change. However, now that has been moved to 1 business day. For 13G, for the passive investors, that deadline has now also been moved to 5% or 5 days of when they cross the 5% threshold. And the amendment has also been moved to the 1 business day after. For 13G institutional and exempt investors, which will be of most interest to most of our audience, financial institutions, and this is also the biggest shift in the deadlines. These reporters who had previously only done an annual report 45 days after the calendar year end are now moving to a monthly schedule of 5 days from month end, and amendments are also moving to a monthly schedule. So an amendment's 5 days from the end of the month in which you've crossed the 10% threshold or any sort of material change. However, there is some relief in the sense that while previously you had to make an amendment for any change in your annual report, now it's at least any material change. If you'll move to the slide 11, we've also summarized in an easy to access chart format an overview of all of these changes, both what they were and what they are now. And this is actually taken from the proposed release itself. With that, I think it is my turn to hand it over to my colleague Curtis to talk about the changes affecting cash settled derivatives.
Thanks very much, Marla. Just checking, can everyone hear me all right?
We can hear you, Curtis.
Excellent, thank you. So on slide 13, A bit of history here. The current reporting regime does generally not attribute beneficial ownership to somebody who holds a purely cash-settled derivative, because that's just a right to payment and it doesn't confer the ability to influence some voting or disposition of the actual equity security, at least doesn't by the terms of the derivative. One exception to that under the current regime is if you have an instrument that is part of a plan or scheme to divest or prevent the vesting of beneficial ownership, then that you're deemed to have beneficial ownership nonetheless. The proposal, that arrangement has been subject to a lot of academic criticism, as Eddie mentioned, and the reasons underlying that are concern that firstly, there could be the derivatives counterparty will generally acquire the cash equity securities or some other instrument to hedge its position, and there's concern that firstly there could be side deals to allow for the cash settled derivative counterparty to acquire those from the dealer. There was also concern that a large immobilized hedge position, if it's not voted, could magnify the voting power of the holder of the derivative instrument. And finally, there's a concern that those positions could be used to, if they're publicly announced, to gain influence or a seat at the table. This proposal would bring certain cash-settled derivatives explicitly within the instruments that confer beneficial ownership. And it would do that by applying to cash-settled derivatives as defined for Section 16 purposes. The definition is here on slide 13, and for current purposes, schematically, you could think of that as being, for instance, a cash-settled call option on an equity security. It's significant that this proposal excludes security-based swaps, because those are dealt with under an earlier proposal from December of last year for Rule 10b-1 for the reporting of security-based swap positions. So you can think of this as a cash-settled call option, but perhaps the more paradigmatic case of a synthetic ownership position, a total return swap, a so-called Delta 1 instrument, is not within the scope of these rules. And there's a certain irony here, because a activist investor that's trying to use a derivative to gain a covert foothold would generally find a total return swap much more conducive to that purpose, because you know what the theoretical hedge position would be at all times, whereas a cash-settled call option, the so-called theoretical delta of that hedge position would vary over time in a manner that couldn't necessarily be predicted in advance. So with that as context and background, if I could go to slide 14, please. So as I mentioned, the proposed rule 13D-3E1 would deem holders of cash-settled derivative securities to have beneficial ownership if the derivative is held with a purpose or effect of changing or influencing the control of the issuer of the reference equity securities, or in connection with or as a participant in any transaction having that purpose or effect. Now cash-settled total return swaps are outside this proposal, as I mentioned before. And in a bit, I'm going to go into a comparison of those two regimes. So I could have slide 15, please. This slide reviews very briefly the reporting methodology, the so-called deemed beneficial ownership percentage under this proposed rule. So it's the quantitative element here. And what this says is that you look at the terms of the cash-settled derivative, and if it's something like a call option that gives you, a number of securities and a strike price, you would then take that number of securities and multiply it by the theoretical delta of that derivative, which can vary over time, say between 0 and 1, depending on whether the share price is above or below the strike price. And that would be the number of securities that you're deemed to beneficially own. However, not all instruments refer to a number of shares. Some would have a notional amount, which is a dollar amount. And for those instruments, you convert into a deemed owned share position by firstly dividing by the current market price you get to a number of shares and then normalizing that by the delta. Now, the important point to note here is that the market price and the delta could vary daily, and as a result, the the deemed beneficial owner would move around and potentially could do so very rapidly. For instance, a call option that is near the strike price and near expiry will have a delta that could oscillate very rapidly. So that's one aspect of the practicality of this methodology and of the regulations in general that we expect commenters will address. For purposes of the calculation, only long positions are counted, short positions aren't netted out. Now, I promised to give a brief comparison with Rule 10b-1, and there's some overlap in the methodology in that these two tests here, the number of shares test and the notional amount test, appear in Rule 10b-1, and the 5% threshold that's relevant for 13D reporting would also be a trigger under Rule 10b-1. But the Rule 10b-1 test for security-based swaps is also more sensitive in that it has an alternate trigger that is triggered when the notional amount surpasses $300 million, which could be, depending on the size of the float, much less than 5%. And it also has some bells and whistles in it, whereby if your percentage threshold is above 2.5% or your deemed notional threshold is above a certain sub-threshold, then you aggregate other positions, namely physical positions and certain option rights into the numerator to decide whether you're subject to that regime. So it's a bit more sensitive, and arguably, if you had a choice, you might want to be under the 13D regime rather than the 10b-1 regime, but that involves some arbitrage around the terms of the instrument, which would have other effects on the commercial purpose and characteristics. Slide 16, there was also an amendment to Item 6 of Schedule 13D to make clear that cash-settled derivatives are within the scope of that disclosure of related contracts or arrangements on the equity securities. Generally, I think most participants have taken the view that these types of cash-settled derivatives are within the scope of Item 6, but the SEC in the release says that that's not entirely clear because the instruments don't put you in privity with the issuer, and because the express examples in Item 6 don't refer to them. So this would remove that ambiguity to the extent people are relying on it as a basis for not including cash-settled derivatives in Item 6. So with that, I believe it's back over to you, Marla.
Thanks so much, Curtis. So the next element of this to discuss is the definition of the term group, which is really so key to these filings. Under the current regime, group is not a defined term. However, in the court cases where this has been looked at, and kind of the general view has always been that to form a group, there has to be some sort of agreement between the members of the group. However, in the new rule, they have set forth an actual definition of group, and this definition does not require any sort of agreement between the members of the group with respect to their actions in the stock of the issuer. And not only does it not require an agreement, simply sharing information about an impending filing of a 13D could result in a group being deemed to be formed. Or if you're sharing information about the 13D filing where that information is not yet public, or you're trying to get others to act with respect to the stock. Where there comes definitions, there also comes exemptions. So in addition to setting out a new specific definition, they've also outlined 2 exemptions. The first, more general exemption, is that 2 or more people will not be deemed to have formed a group solely because of communications, when those communications aren't kind of with the intent of changing control of the issuer, influencing the issuer. And the participants in that group are not really trying, or they're not obligated to act on that conversation or those actions that they're considering. The one that's a bit more specific, this is on slide 21, for derivatives counterparties and for institutions is that solely by virtue of entering into a confirmation or a transaction in a derivative, when that's in the ordinary course of business and is a kind of bona fide agreement, purchase and sale agreement, and there's no intent to influence or control, or the transaction is not in connection with if the derivative is not in connection with any transaction having that type of intent, that would also be exempted from the new group definition. Obviously, that second part, that it cannot be in connection with any transaction that has the intent to influence the issuer, could be very broad and problematic for a lot of the current business lines that we see.
So for those of you who aren't familiar with Section 16, Section 16 of the Exchange Act requires directors, officers, or really executive officers, and 10% stockholders of publicly held companies to report their beneficial ownership of equity securities, of registered equity securities, as well as changes to beneficial ownership. Section 16 is an entirely different reporting regime than Section 13D, and really works hand in hand with Section 16B, which are the short swing profit recapture provisions. In other words, the Section 16, the reasoning behind Section 16 is Congress viewed insiders as people who should take long-term views of their stock ownership rather than short-term views. And under Section 16, if an insider, meaning a director, executive officer, 10% stockholder, purchases and sells a security within 6 months, the purchase or sale, and it doesn't have to be purchase and then sale, it could be a sale and then a purchase in a matchable transaction like that. If you sell it within 6 months, whatever profit you're deemed to have has to be given back to the issuer. So quick example is if you sell a security at $10 and 3 months later buy that same security at $5, under Section 16, you are deemed to have a $5 profit because you take the lowest purchase price and the highest sale price, and you have a profit, you therefore have to give it back to the issuer. So Section 16A, which are the reporting provisions, are designed to publicly announce when there are transactions in the stock. And those of you who have ever had to deal with it know that it's important. The public reporting regime is particularly important in Section 16 because Section 16 also provides a private right of action by a stockholder to go after an insider who has a Section 16 profit. And there's actually a small bar. It's about 3 or 4 guys who I think mostly live in suburban New York and in Florida, who have sophisticated computer programs that review all Section 16 filings to try to determine whether or not there's been a short swing profit. So Section 16, totally different reporting regime. However, just to complicate the world, you're probably saying, okay, well, hold on a second. If you're telling me it's a totally different reporting regime, we've been talking about Section 13. Now, why are we talking about Section 16? So as I was about to say, to complicate matters under Section 16, there's a bifurcated analysis. The first question is, and we'll put aside whether or not you're an officer or a director, because we assume we know who that is. But whether or not you are a 10% stockholder subject to Section 16, you first look to the beneficial ownership rules of Section 13. So if you beneficially own more than 10% of the issuer stock, you are then subject to reporting under Section 16, full stop. Then you look at what you actually report under Section 16, and what you actually report under Section 16 is based on pecuniary issues. In other words, do you have any financial interest in that stock? So going back to what Marla was just talking about, a group, the best example is really, I could be a member of a group, that group owns 10% of the stock, or we'll make it easy, it owns 11% of the stock. Therefore, I am a 10% stockholder because my group owns 11% of the stock. All of the members of the group are then subject to reporting on Forms 3, which is the initial going over 10%, and Form 4, which you have to file whenever you change beneficial ownership. And that then looks at whether I actually have a financial interest in any of those shares. And it may very well be that I own 0 shares, or I will report 0 shares under Section 16 because I have no pecuniary interest in any of those shares. Or it could be that I only have a pecuniary interest in 10 shares or 2% of those shares. So it's really important to understand that Section 16 first looks to Section 13 to determine whether or not you are a reporting person. And then there's a totally different analysis as to how many shares you actually report. I'll point out, and Marla mentioned the shorter reporting periods under Section 13. Under Section 16, we have significantly shorter reporting periods. And so certainly insiders are used to reporting transactions much quicker. Again, if you are a member of a group and you think that you're a Section 16 insider. Okay, next slide, or I jump to next one, please. So as we mentioned, the proposal was put out last month, and under the SEC's, in the proposal, it said that comments are due by the later of 16 days following issuance, which is April 11th, or 30 days following publication. Under the Administrative Procedures Act, before adopting final rules, a government agency, for example, the SEC, is required to publish proposed rules and solicit comments. While the APA generally requires a minimum comment period of 30 days, the SEC typically leaves comment periods open for a much longer period of time. So for example, in December 15th to be exact, the SEC proposed new rules on issuer share repurchases and a new Form SR. Though the release was issued on December 15th, and the comment period there runs through April 1st, so it's a much longer comment period. We might take from this, if you have a jaunted view of the world, that the SEC isn't really looking for comments because of the very short period. Having said that, a lot of people are scrambling to try to get comments into the SEC. And if you have any interest in doing that, feel free to give us a call. And with that, I'm going to turn this over to Andrew Norell to talk about some practical implications of the new rules on shareholder activism and M&A.
Thank you, Eddie. So want to talk about sort of some of the practical implications, as Eddie said here, and start with shareholder activism. The first and most obvious change here in effect has to do with the stake building ability that shareholder activists have. And this was cited in the release itself, some of the concerns we've already mentioned, but shortening the window after the activist crossed a 5% threshold to 5 days from 10 really does put pressure on the activist to fill out or finish its stake in a much shorter period of time, depending on the liquidity of the stock and the size of the company. That could actually have an impact on the share price and the price at which the activist can continue to buy. And that's because activists want to be somewhere around the 5 to 10% sweet spot generally, if they're going to be taking this size of a position. Eddie talked about the significance of becoming a 10% shareholder and not being subject to Section 16. And many activists don't want to be subject to the 6-month short swing profit rules. So somewhere in the 5 to 10% range is where a number of stakes end up. The SEC noted in its release that there's a median of about 8.4% for initial 13D filers in some of the samples it looked at. And it also cited a private study that found about a 6.3% position for hedge fund filers. So shortening this window will put more pressure on activists having to complete their positions before announcement or disclosure in a 13D, because obviously once the 13D is filed, share prices take a pop, and retail and other shareholders are all aware that there's an activist in the stock. I think this is particularly a concern for smaller and mid-cap companies, perhaps maybe less for the large cap companies and those activist campaigns. That's because it might be that with some of these larger cap companies, activists don't even get to the 13D threshold, given that they could put a large amount of cash to work in a position and still sit below the 5% threshold. But with the mid cap and particularly the smaller companies, these 5 and 10% thresholds become important, and need to think about the effect of having to disclose that sooner, as set forth in the proposed rules. We've talked a little bit about the cash settled derivatives, and Curtis described how the certain of these security swaps are not covered here. It just, I think we note that this puts more pressure, or at least eliminates potential alternatives to activists using some other cash settled derivative securities as alternatives for actually going out and buying shares. And so again, some of the creative solutions that have been used by activists may not be available under these new rules. If we go to the next slide, please. Okay, so the second big activist area that I think is impacted here is Wolfpack activities. Now, Wolfpacks are coordinated efforts by activists which to avoid a group, and which also result in large amount of shares being bought. That this is really a function of where the group rules have been and how people have been able to work around them. So it's sort of confounded the 13D regime for quite a while. And it's possible that courts wouldn't even, under the current rules, find groups to have been formed between activists, even though there's empirical and anecdotal evidence of coordination. And in particular, if each of the activists sits under the 5% 13D threshold, it's possible for 15, 20, even 30% of the stock to be held by activists, but no one to have reported it. Wolfpacks are used mostly, by activists to build support with other activists. There's talk of it, that, again, anecdotal evidence that there's clubs. Certain activists seem to work together. One activist buys the stock and other ones are also coincidentally buying it at the same time. This helps reduce the risk of a failed campaign if the activists go public with their campaign. It also builds support for private activism when a activist wants to approach a board or management and demand changes in the company. It's possible that multiple activists showing up, if you will, on different days to meet with the company would definitely send a signal to the company that there is a strong activist interest. And again, this would all be undisclosed publicly because they could all be sitting below the threshold. So some of the proposed changes really go to trying to stop some of these Wolfpack activities. The one change we mentioned before about clarifying that an agreement's not necessary. The SEC has said that this was a perhaps misconception, but it's never been necessary, particularly looking at the statutory language as compared to the language of the rule. But they make that clear. And this additional change going to Wolfpacks in particular with respect to a 13D filer tipping off other potential buyers that they have an imminent 13D filing with the intent of disclosing that information so that other potential buyers go out and actually do purchase the stock, making it clear in the rule that this does become a group, this tipper-tippee type of situation. I also note that the proposed exemption permitting shareholder communications and concerted actions, which really were put in place for the passive investors, don't apply to Wolfpacks. So I think there's a question here as to what really is the purpose of all this. The SEC, is it making clear some of these new views and new rules just to attack, or I should say, put the clamp down on these Wolfpack type activities? Or is this a signal of something bigger? And this is really what activists have to consider. Is the SEC going to become more aggressive in its approach to Wolfpacks and putting these rules on the books, and then perhaps looking more into specific situations where Wolfpack activity could be alleged? As Marla mentioned, and as mentioned in the release, the SEC points to the fact that an agreement's never been necessary and that group activity is demonstrated by circumstantial evidence. The list of evidence includes whether there's a common plan or goal between the participants, common desire to change the management, strategy meetings that participants might have with lawyers, coordinated stock purchases, which is clearly a Wolfpack activity, solicitations of others to join the group, and communications between the members. So it's really a question of whether future enforcement actions will be taken by the SEC to actually get into the details of some of these activities, or if the SEC is perhaps putting out these new changes and taking maybe more of a wait and see attitude. This is something I think that activists who do act in wolf packs would need to consider. And finally, we note that in particular, being a part of a wolf pack, if it's deemed to be a group, could be dangerous if it gets you into a Section 16 situation if you're an activist and you want to keep your ability to sell shares flexible because, again, of the short swing profit rules. So a wolf pack being deemed a group could have a number of problems for an activist. Go to the next slide, please. So we wanted to just note some M&A considerations in light of these changes to the rules and highlight these 4 areas. The first is with respect to hostile deals. As a general matter, we don't think the proposed changes are likely to have a significant effect on hostile deal practice. As Eddie noted at the top, when the Williams Act was put into place, there was quite a bit of hostile activity. And of course, there just wasn't enough information out there for boards or shareholders. The current defensive mechanisms that are available for corporations, as well as some of the statutes that have been put in place, really do affect a change in hostile deal practice since the time the Williams Act was enacted. And moving the deadline, for example, from 10 days to 5 days, in our view, probably won't change much. Right now, the big change since the Williams Act is still the poison pill, and boards can put those in place to protect against a threat. So there's been a difference in the last 30 years as to how the poison pills are deployed. It used to be that most all companies had a poison pill in place, just as a general matter. Lately, companies have pulled them all and deploy them off the shelf when they do perceive a specific threat. With regard to potential hostile takeovers, there are ways that the company can find out even beyond the 13D. And we note, for example, the HSR statute requires when a party wants to go over the $101 million threshold and they're looking to take control, they're going to have to file with the DOJ and FTC. This is also notified to the target company. So boards can find out on a private basis, if you will, that their company could be potentially under attack. And again, poison pills can be quickly deployed. In addition, when the Williams Act was enacted, there weren't the panoply of anti-takeover laws in place that many state corporate statutes have. For example, the Delaware Section 203 prohibits transactions between a 15% or more stockholder and the corporation in a business combination for 3 years, unless certain approvals are received. So there are additional statutory protections. So again, we don't believe that some of these changes here on the margins to the 13D rules are going to affect hostile deal practice in a meaningful way. The second thing I want to talk about is going private transactions. Going private transaction is when an affiliate of a registrant takes the company private. In a number of cases, these affiliates might be 13D filer. For example, we've seen a lot of situations where early stage drug companies, it might be public companies, have collaboration arrangements with larger pharma companies, and often equity is given to the pharma company as part of that collaboration arrangement. In those cases, these pharma companies, these large pharmaceutical companies would become a 13D filer. We note that because part of the requirements in the 13D is to state whether you have any intention to engage in any of the transactions described in item 4 of the 13D, which includes the transaction to take over the company or enter into a merger or a similar business combination transaction. So the question is, when the affiliate decides to change its intentions from simply holding shares as an investor to taking over the company and taking it private, making that disclosure in a 13D amendment. The old standard, of course, is promptly. Promptly could be 2 or 3 business days, or it could be longer, as it has been found. But now it's very clear that there's a 1 business day bright line for when the change in intention has to be disclosed in an amendment to the 13D of the affiliate. So we point this out because, in particular, affiliates who want to engage in these transactions and structure them prior to making disclosure have to be very careful in their transaction process, and again, not make that decision or come to that conclusion that they want to do a going private transaction until they're prepared to disclose it. And in this case, the new rules make clear that it has to be in 1 business day. And of course, once a transaction or a transaction intent is disclosed, that's the kind of thing that will affect the stock price significantly. The third thing I'm going to talk about here is poison pills. So poison pills, obviously developed after the Williams Act was put into place, have developed in the last several years to cover a number of things which are excluded from 13D disclosure. So they have provisions that deal with when parties are acting in concert, so that they aggregate the holdings of the parties to determine whether the poison pill trigger has been tripped. And this is sort of in the concept of what the anti-Wolfpack, if you will. There's also provisions in poison pills now that cover synthetic equity and derivatives to be counted for purposes of the trigger. So these changes have been considered by courts over time. And I think the most recent significant case here is the Williams Company's case, which came out last year. It's a Delaware Chancery Court decision, which was affirmed by the Supreme Court. And in that case, the court was looking at a very aggressive poison pill, one that had a 5% trigger, not based on NOLs, but a 5% trigger based on any activity. And the pill was ostensibly put in place because of a concern about shareholder activism triggered by the drop in prices from the COVID-19 pandemic. It also had very aggressive provisions in it regarding parties acting in concert, what kind of securities counted for purpose of the trigger. And so the court had to determine whether the terms of the pill were a reasonable response to the threat that was posed. The courts, when they examine these poison pills, at least in Delaware, they put the unical scrutiny on them, which is there has to be reasonably recognized threat to the company, and then the response has to be reasonable in relation to the threat. So in determining the second prong of that, which is whether the response was reasonable, the court noted, among other reasons, that the provisions of the pill were beyond what the federal rules require. And there was a rather long discussion of 13D, but in some, the court was saying this goes beyond the terms of what 13D requires. Beneficial ownership captures synthetic equity, for example, which the federal rules don't. The acting in concert provision goes beyond the default express agreement required under the federal rules, which is how the court looked at that. And also the passive investor definition, which would exclude certain investors from tripping the pill, goes beyond the traditional influence or control of the company default provision of the federal rules. So we note here that it'll be interesting to see that with the changes here proposed with regard to 13D, whether this will also affect pill practice and what the courts find acceptable, and perhaps what the courts might find as acceptable extensions of the concepts that the federal government seems to be focused on. So that's to be determined. But again, I think poison pill practice will certainly have to take account of the current proposed amendments to 13D. The last item I want to talk about a little bit is appraisal rights. And this really relates to appraisal arbitrage. So appraisal arbitrage hedge funds were in their heyday probably about 10 years ago. and in particular in Delaware, because it has a very clear path to how appraisal works and has rather favorable rules for dissenting shareholders. Now, the strategy for an appraisal arbitrage fund is to buy shares of a company after the announcement of a merger. So after the company is going to be taken over and appraisal rights would be available, the ARB fund goes out and buys shares. And they have up until the date of the meeting, for example, when it's a one-step merger, they have up to the date of the meeting to buy those shares and then, of course, demand appraisal for them. The key point here is that these ARB funds like to run under the radar for this. And that is because if a number of funds file 13 Gs or 13 Ds, but more likely 13 Gs, that they have taken positions and shareholders start to see how many shares are starting to demand appraisal or will demand appraisal rather, because they know the identity of the ARB funds, then it's possible that the shareholders don't support the deal. And the key with appraisal arbitrage is that you don't support the deal, you don't vote for it. However, the merger has to be approved because the merger has to happen. And at that point, then you would go and demand appraisal. In one case, the Dole Foods Company merger, there were 2 votes. There was a majority and minority vote in there. But 4 hedge funds had taken large positions in Dole stock for purposes of seeking appraisal. And the majority and the minority vote passed by less than 51% of the outstanding minority. And that's because so many shares were on the sidelines. So it's important, and these ARBs often declare or disclose their holdings right at the time of the meeting or in the 1 or 2 days leading up to the meeting to avoid having the market detect what they're up to. It's important for them to sort of stay under the radar as much as possible. Again, we mention this only because if they're in the situation where they're going from a 5% stake to a larger stake and they want to take a bigger stake to demand appraisal for, they need to operate within this shorter window, noting that 5 days will be the time that they'll have to make their filing instead of the previous 10 days once they cross the 5% threshold.
There are a couple of questions that we've got, and I think, Andrew, they look like they're probably for you. The first one is, will the burden of proof become that you didn't know about the pending 13D filing when you buy stock?
Yes, I think, yes. I think on that, you would be knowing of that information and trading on that information. So they would have to show that. The government, I think, would have to show that you did.
Okay. There are 2 more. Actually, another one popped up. I'll take this one. Under the proposal, would an institutional investor filing a Schedule 13G be subject to Section 16 reporting requirements? There are exceptions under Section 16 for institutional investors that may or may not be applicable. So not every institutional investor that goes over 10% will be subject to Section 16, but it is certainly something that an institutional investor would have to take a look at. And by the way, the proposal doesn't change anything vis-a-vis that. Currently, an investor who owns 10% would be subject to it. All this really does is change the definition of a group and things. So an institutional investor on its own that owned 11% before the rules would be in the same position as owning 11% after the rules. And Curtis, I think this one is for you. Maybe. Mm-hmm. Can a TIPI be forced to comply with the proposed new Section 13 and 16 rules, even where it only enters into cash settled derivatives of a de minimis amount after being tipped?
Yeah, I don't know that is, for me, is that goes to the 13D amendments, the group amendments, I believe Marla covered.
I'm happy to answer as well. Like Curtis said, I think it would depend on whether or not you are considered part of the group. So if as a TIPI you would be part of the group, then yes, you would be subject to the filing amendments as as part of the group when you invest, and it's considered a beneficial ownership stake.
Okay, thank you all for participating.